So, shall we start the session?
Yes, please.
Okay, sir. Hello and good evening, all. Mr. CGA Thomas, Assistant Professor from Department of AI, and I'm going to be the moderator of today's program. Now, let's begin the program formally. Most honored Chief Guest, Advocate J. Suresh, Principal Dr. Matthew K., Vice Principal Professor Thomas George, Administrator Ms. Suja Joseph, Director Mr. Jose KK, Academic Coordinator Professor Ranjit Varghese, Webinar Coordinators Dr. Smita C. Thomas and Mr. Ajishis, and dear faculty members. Hearty welcome to the webinar series on intellectual property rights organized by Mount Zion College of Engineering, Kadaminita. Now let's begin with a silent prayer. Thank you all. On this wonderful evening, we mark the beginning of three-day webinar series on IPR. Dr. Smita C. Thomas, Associate Professor, Department of Computer Science and Coordinator of this webinar. I would now request Smita ma'am to deliver the welcome address and also to introduce a guest speaker to the participants. Over to you, ma'am.
Warm greetings to everyone present here. On behalf of Mount Zion College of Engineering, Kadamaretta, I will honored to welcome all of you to 3 days webinar on intellectual property rights. It's our pleasure to invite our chief guest, Mr. J. Suresh sir. He is a qualified patent attorney specialist specialized in drafting, filing, and presentation of domestic and overseas patent applications for inventions based on electrical, mechanical, and chemical domains. He is an advocate with rich techno-legal experience of over 25 years in the domain of intellectual property rights. He also handles filing and prosecution of both international trademarks, design, and copyrights. He also handles IP litigation. He also has an expertise in handling IP portfolios of US, European, Japanese, Korean, and Chinese companies. He regularly delivers lectures on IP laws and practices in various organizations and universities in India and abroad, including Japanese Patent Office, Japanese Patent Attorneys Association, Graduate Research Institute of Policy Studies, and Japanese Intellectual Property Association. I welcome you, sir. Once again, I welcome all of you to this webinar. Thank you. Thank you all.
Thank you, ma'am, for the warm words of welcome. Without taking much of time, I invite Advocate Suresh J to take over the presentation. Now the forum will be yours, sir.
Thank you so much, ma'am.
Yeah.
Good afternoon and a warm welcome to all the participants who are virtually present. And it is indeed my pleasure to be connected with you all this afternoon, rather evening today. At the outset, I would like to thank my teacher and my respected friend, Dr. Mohan Ram, who has taken this initiative to bring me into this. I'm also thankful to Dr. Smita, who has been very active in conducting this webinar. And my special thanks also to the principal and director and other officials who have contributed to this event today. So I've been introduced a bit. It is indeed a bit difficult whenever there is an event like this where the speaker or the resource person is not able to have eye contact with the participants. Anyway, We will try and make this as effective, as interesting as possible. So today we are going to look at some of the interesting features of intellectual property rights. Whenever we look at the try and understand the term intellectual property rights, for me at least, it is like an enigma. Like, even though I've been associated with this field for over 25 years, still I find whenever I encounter this term or expression, intellectual property, I sometimes feel that what the understanding that I have is not enough. Now, this session is about 60 minutes, and we are going to touch upon some of the interesting aspects, like we would be looking at what is intangible property, just to set a context when we are going to look in detail on intellectual property. And also we will be looking at various species of intellectual property rights. And most importantly, the territorial nature of intellectual property rights. And of course, we will be looking at the significance or importance of intellectual property rights. Now, when you look at the term property, it is the law that defines the term. If one way to put it loosely, it can be said that a property is the one which can be bought or sold. In other words, it's the ownership. It determines the ownership. So, when a law defines a certain thing as a property, generally property can be classified into two types. The first one, of course, is a tangible or physical property. When I say tangible or physical, it means that this particular species of property has a touch and feel. That means you can have a physical contact with that. And there are generally, if you look at the types of tangible properties, there, of course, we have real property, that is, land is something which is generally referred to as a real property. And anything connected to the land, such as house, is also deemed as or considered as a real property. When we say personal property, that is something which is personal or movable, or something which you have acquired. These are things generally categorized as personal properties. Public, for example, railways is a public property. And private is something which is of private in nature, acquired and used. So once we know these types of physical properties, the thing that comes to our mind is that since it is defined by law, protected by law, or the rights are bestowed upon by law, and these rights are considered as positive rights. Why is it that we term this as a positive right? That is, ownership over a land, we are calling it as a positive right. Why is it so? It's simply for the reason that a person owning a property or a tangible property, say for example, a house, the person has a right of ownership as well as right to use. So these are the two important things that we need to keep in mind when we move on to the term intangible property. That's the first one is right to ownership and right to use. That is, if I own a house, I'm the owner under law, and I have right to stay there. I have right to use it. I have right to sell. I have a right to let it out, so on and so forth. These are all something which we call them as positive rights or absolute rights. Right? Now, let's move on from tangible property to the intangible side, which is the focus of today's session. Whenever we talk about intellectual property, it is said that it is creation of mind or intellect. That means one of the faculty of a mind, it is a creation of a faculty of mind or by intellect. Therefore, this type of property is also called as knowledge goods. Why is it something which is intangible, which cannot be touched, which has no physical presence? Why is it that it's so relevant for us today? Because it has tremendous commercial implications. That is, in a technology-driven economy, this has become a new paradigm to determine market capitalization. Let me tell you a small story which can help us in understand what is this intellectual property is. So there was a king who was very rich, and after a certain period of time, he could not identify or find what is the purpose of life. So he goes into a forest in search of a sage. And when he finds him, he asks him, "Hello, respected person, can you please tell me what is the purpose of life?" The sage looks at him, and then after a while tells him, "You go into the forest little while, and then you will find 3 people or 3 persons. Then you will know the purpose of your life." So this rich person goes ahead, and while walking into the forest, he notices a woodcutter cutting wood. Then he thinks, "Hey, he is just a woodcutter. What he is going to tell me about purpose of life?" So he proceeds further. Then he finds an ironsmith working with iron rods and iron sheets. And then he said, "Oh, how can this person tell me what's the purpose of life? He is too small for that." So he moves on. And then he goes a little further. He finds another person who was taking those metal sheets or iron sheets and then making them into small strings from there. So this rich person gets visibly disappointed. He said, "Yeah, what the sage misled me into this, and he said that I would find a purpose of life and nothing I found here." So he moves forward, and then rather he gets back. While coming back, he hears a nice music, and that was music played on a violin. And then that's a point where he realizes, "Oh, that is what sage meant by this. That is, wood, when it is cut, it is raw, and the raw wood is converted as a wood for the violin, and the iron strings that are made, that are used for this violin. So when that particular instrument is played, you derive a music, or music is played on that." So intellectual property is something which is very similar. We encounter this every day in our lives in different forms. Sometimes we may fail to recognize, sometimes we recognize and leave it, and very rarely we see, recognize, and tap the potential of the intellectual property right. Okay. So intellectual property covers a wide range of activities, be it economical, cultural. And why do you say that it is cultural? Say, for instance, in India, it is our tradition to say that knowledge is for sharing, not for owning. Atta kariche vidya. So when we have these cultural leanings, that also affects or in a way influences the way we understand the term intellectual property. And also the IP laws are very complicated. You have different laws for various intellectual types of intellectual property rights, which we're going to see. We have national laws, such as we have Trademarks Act, we have Patents Act, regional laws. So we have a European Union has a patent law which covers throughout the European Union, and of course international like treaties like TRIPS. So these IP laws are complicated by virtue of this diversity, and also because it is related to, or it is a techno-legal activity that it is going to address. Now, let's come back to the knowledge goods. Why is it this intellectual property is considered as knowledge goods? When you look at the term knowledge goods, there are two significant characteristics that strike to our mind. That is, knowledge goods are inexhaustible and they are non-excludable. Let me give you an example to understand these two characteristics of intellectual property or knowledge goods. So for instance, I have a football, and after having watched how these football characteristics of football, how this game is played, then I got an idea. The idea was, if I could use a different material, say for example, foam, and using that different material, if I could make a football, that football would fly much higher and much lighter than other known footballs. So this is a knowledge which was conceived in my mind, and therefore I can have this idea in my mind, so I can make any number of football using this idea. So this idea, it cannot be exhausted from my mind unless, of course, my brain gets damaged. So therefore, this idea is something which we call it as an inexhaustible idea. It's a perennial, like something like it keeps coming. Then what is non-excludable? Say, using this idea, I make a football and I sell it. So I am dispossessed of this particular property, that is football, from me to a buyer. So it is excluded from me. Football is excluded from me. Whereas that idea still remains with me. That is, if I make and sell one football, I can also make and sell n number of footballs using that idea that I have in mind. So therefore, it is non-excludable idea. So these are the two important characteristics whenever we talk about a term called intellectual property. Now, what are the various forms of this knowledge? Forms such as we have codified knowledge, that is something which is coded and having no utilitarian function. Like for instance, if a novel is written, it is nothing but a codified knowledge, and it has no functional utility, right? And it's not a machine, so that where we can attribute functional characteristics. Tool knowledge, so that is, using this knowledge, you develop a machine which has a functional utility. That is tool knowledge. And of course, personal knowledge, that is trade secrets, or we can also call it as know-how. So these are some of the important forms of knowledge. So from where we derive the species of intellectual property. Now we are moving on to a very important aspect of considering this intellectual property, that is, where do these rights exist? Whenever I talk about an idea which is in my mind, what is that protection I'm getting? What are the rights that I'm getting? That is legal rights which result from intellectual activity. That is, industrial could be scientific, literary, or artistic fields. So these are the rights that are originating from the intellectual property, from the intellectual activity. So the important thing that we need to bear in mind here is that legal rights do not apply to physical object, that is the end result in which the creation may be embodied, whereas legal rights apply only to the intellectual creation. So please look at the graphic that I have on this slide. On the left side, you can see the creation of an idea in my mind. So to which the legal right is provided or the protection is provided to the idea. But however, if you see on the right side, if I have an idea how to make a robot and I make it, the intellectual property right does not extend to the end result, that is the robot that you see here. So this is the clear distinction that we should have whenever we talk about intellectual property rights. So the rights only are limited to the idea or the knowledge, but it is not, cannot be extended to the end product of a particular idea. Say, for example, I buy a Coca-Cola. Coca-Cola is a reputed trademark. I pay for it and then I buy it. So now I can drink that Coke which I bought. I can also fill the bottle with water and then reuse it, or I can just throw it away. That means the property, the tangible result of the intellectual property right, have become the owner. So I can do whatever I want. Now here, say for example, after drinking the Coke from the bottle, say I develop a Coke from my side and then put a label on that, say Coca-Cola, and then try and sell it. Can I do this? Therefore, here, what is it that we need to see here is the ownership that I have is only limited to the physical, tangible end product that I have purchased, but not to the intellectual property that is inherent or for which I paid for it. Okay, good. Now let us look at the differences between tangible and intangible. So tangible, they have physical existence, which is not there in intangible. Tangible assets are depreciated. So for example, you buy a car and the next month you find your value of the car is reduced or depreciated because of wear and tear, whatever it is. Whereas in case of intangible assets, we don't call them as depreciation, we call it as amortization. That is, if you have a trademark, we will consider that the value of the trademark and also the legal rights that you have in the mark and what is the life of this mark. And accordingly, you set a amortization value to the intangible asset. Tangible assets are easy to sell, but it is difficult to liquidate intangible assets because they are intangible. Setting a value is very difficult. If at all we set a value, it will be a notional value. So there is a difficulty in liquidating intangible assets in the market. So cost of tangible asset can be easily determined. Say if you want to buy a computer, yeah, you know how much it costs and you can buy it. But if you want to buy an invention, or if somebody has come out with a good idea which you want to buy and then use that, then comes the difficulty of how much is it going to cost? Because it's whatever value is going to be a notional value. And if you look at the examples of tangible assets, as I said, we have vehicles, plants, machinery, etc. And in case of intangible assets, patents, trademarks, designs, and copyrights, etc. Now here we have a little assignment here. So probably I can also join in doing this with you. So when you look at the cash currency, does it appear to you as a as a tangible or intangible? To me, it may appear as a tangible, right? Because I may say, yeah, I have a touch and feel in this, and it has a monetary value. So therefore, according to me, it is tangible. You may differ. Yeah, you are within your rights to do that. Next is furniture. Furniture is very easy. So because it's a physical object, it has a touch and feel, and it has a value. So therefore, I can consider this as furniture. Now comes the stock. Is it tangible or intangible? Right. So we will revisit this because we are just begun understanding the concept of intangible asset. We will come back and decide maybe after a while what exactly the stock is. Is it tangible asset or is it intangible? So tangible means touch and feel. Say if you have a shared document, nowadays everything is digital, so you cannot even touch and feel, right? But it has a value. Okay. Now next comes your goodwill. Is it tangible or intangible? I will give you an example before categorizing these terms. Say I'm interested in buying a company, and I did a survey, and then I found the value of company, say, is 1 crore. And after evaluating that particular company, then I said, okay, let me pay 1.5 crores, 1 crore 50 lakhs, rather than paying 1 crore. Why? Because in my mind, the value of the company is much greater than the assets that the company holds. So that's the reason why I pay 50 lakhs more than the asset value of the company. In other words, I pay premium to it because that company has a lot of goodwill in the market. And for that goodwill, I am paying an extra money for that. So therefore, goodwill is nothing but an intangible asset. Okay, now let's move on to fixed deposit. What do you say for this? So I'll put a question mark again for this. Then customer data. The customer data is something which is very unique for any organization. Say if I'm running a company, say for over a period of say 20 years, I accumulate a lot of customers, and then how customers work with my products, so on and so forth. And I use this data to leverage my sales or improving my sales. So this customer data, if you look at that, it's just a physical document, and where it may have names, numbers, so on and so forth. But it has a tremendous value for me. That value is difficult to quantify, or it may be difficult for others to quantify, or others can derive much more value than what I am doing it now. So forth, customer data has an intrinsic value which can be monetized. So therefore, it could be treated as an intangible asset. Now let us come to another thing, that is licensing. Say for example, nowadays you might have noticed many franchises coming up, and then they are providing services by using a popular name as a brand. Say for example, we have Apollo Diagnostics, and Apollo is a name of a very reputed organization, wherein they say, okay, I will give you a license, you can start a diagnostic center in your area. I will give you a permission to use my name. In order to enable you to use my name or other brand, I am going to charge you, say, if you are charging 100 rupees to a patient for diagnosis, you have to pay me 20 rupees. So 20 rupees is the royalty that the franchisee is going to pay to the franchisor. And the agreement between the licensor and the licensee will be in the form of a license. So license is nothing but a document, and per se it may not have any monetary value. So monetary value will arise when the licensee sells or provides services for a consideration, and some consideration is accrued to the licensor. So therefore, these license agreements are generally considered as what you say, intangible asset, because per se, because they are just documents, and then physically they may not have that value. Okay. Now let's move on. Look at this machine. It looks like a complex machine. It is nothing but a textile weaving machine. And this was invented in the year 1924 by a person called Sakiji Toyoda. And in this invention, this inventor was able to overcome a problem that was present in such machines. The problem was, say, whenever the weaving operation is going on, textile weaving operation, threads are used to weave the fabric. And as these threads are used, they used to get, they had to be replenished because of this, as and when threads are used. So one had to get them replenished. And in order to do that, the machine had to be slowed down or had to be stopped to replenish the threads. So this inventor came with a solution wherein even without altering the speed or stopping the machine, thread could be replenished automatically into the weaving machine. And once he had this idea in his mind, he approached his friend and said, look, I have this idea, what to do with this? So his friend advised him. He said, go and file a patent application. Imagine this was in the year 1924. And then the Sakiji Toyoda went and filed the application. And then he got a patent for this. At the time in England, textile machinery was one of the major industries. And one of the companies in England, they were very interested in buying this machine, and they paid 1 million yen in 1927 to Sakiji Toyoda. 1 million yen, roughly about 60 crores now. And they bought this machine. Sorry, they bought this idea. They bought the patent from him, intangible asset from him. And Sakiji Toyoda, he used that money as a seed money to start a company. And the rest is history. We all know by now what this company is. The company is Toyota, right? So that's the power of intellectual property, right? Having said that, it is not always necessary that patents or the intellectual property rights should be of something where you could get a Nobel Prize. No, it could be as simple as what you see here. A cup could be used as a device where you can have storage for food as well. It could be as simple as that. Okay. Now, let's look at the rights. As I was mentioning a few minutes ago, saying that the IP rights are, the tangible rights are positive rights, whereas the intellectual property rights are negative rights. So that is a basic distinction between the rights of the tangible and the intangible. So we have understood the positive rights. That is, you have both ownership as well as right to use. I can do whatever I want with that property. Whereas in case of intellectual property right, in case I obtained legally, therefore, I can consider that I have a right over that property, over the intellectual property. The second question is to be answered here is whether I can use it the way I use tangible property. Here comes the problem. Even though I have a right which is granted under law, I still may not be able to use it. Let me give you an example. See, I have a patent for drug, which is to treat cancer. So therefore, once I have a patent right, that means I am the owner of this patent. So therefore, the question here is, can I make and sell this particular drug, say in India? Do I have that permission to do that? Probably the answer is negative, because even though you have ownership over the invention or you have a patent right over that particular product, drug, but still you may have to obtain a permission from authority like drug controller in India to make and sell that particular product in India. But nevertheless, you can prevent others from making and using it. So that is the fine distinction here. You have the ownership. You may not have right to make and use and sell, but nevertheless, you can prevent others from making and using it. So that is the fundamental concept of exclusivity. When we are going to touch upon the topic of patents next Saturday, wherein we will go into much deeper to discuss this aspect of this negative rights. That is how this right these rights prevent others from using the patented right. And the second important thing is that principle of territoriality. This is a very important thing to consider. So for example, if I have a trademark protected, say in India, the question that would arise here is, if somebody uses my trademark in, say, in a country like United States, can I stop that particular company from using it? So generally, because I'm using the term generally, IP rights do not extend beyond the protected territory. That is, if I have a particular IP right in India, I may not be able to enforce these rights in other countries, subject, of course, to some exceptions that we are going to see as we progress. Okay. After having seen the fundamental principles of intellectual property rights, and now let us look at some of the examples to highlight the territorial nature of the intellectual property rights. Here I'm taking an example of trademark. Whenever you want to have a trademark, what you do is first you should identify the product or the services that you want to provide or make and sell. And then you give a name to that product or a name to that service. And then you start selling it in that name, or you start providing services in that particular name. So when you start doing it, you will go and register that name as your trademark in relation to the goods that you propose to sell. Now, for instance, there is a producer X uses a particular mark in a state A. And the same mark is owned and registered by producer Y in state B. So you are looking at a scenario where an identical mark is used in state A, whereas a similar or identical mark is registered by Y in state B. So here you're looking at two states where there is a presence of an identical mark being used. Probably here you may not get a conflict situation because these producers are operating in two different states, even though they are using an identical trademark, perhaps for identical set of goods. So conflict is very remote in this case, because as long as you both are happy in their respective jurisdiction, probably there is no conflict. Now let us look at another scenario. Conflict happens when one or both seek to operate in the international marketplace. Say state A, state B, and both would like to operate in a state, say, let us, for example, say state D. So X is going there, sorry, X and Y having respective national trademarks, and they are going to operate or operating in a single international marketplace, which is common to them. And there the problems would arise because these two individual owners of that particular trademark, they're trying to use them in one single geographical entity. So there is a conflict, right? Now, let's look at the patent rights. Say, for example, patent A has a patent in United States. I have a list of questions here to answer. Let us try and answer these questions. Can B make and sell X in India without infringing that patent? Even though patent is registered in US, the question here is, can B, a different person, can he make and sell that particular product which is patented in US in India without infringing patent? The answer is yes, because patent rights are territorial in nature. That is, if there is a US patent, rights are confined only to the geographical extent of United States and cannot be extended to a territory, say, India. Now look at the second question. Can B export X to US without infringing? Here comes the problem. Even though B is making that product in India, but in order to sell it, he is exporting into a country where a particular patent for that product exists. So therefore, the moment the product reaches the shores of United States, that action amounts to infringement of that patent in US. Similarly, we have a third question. Can B export, because since I realized that X has that patent for X is only in United States. So why can't I sell it in Europe? Well, you can jolly well do that as long as a corresponding patent does not exist in European Union. European Union is quite a large word, which may not be correct to use because it has 21 countries, and you should have, say, for example, German patent, British patent, and then Italian patent, so on and so forth. So that depends on in all these, each of the unions, where that particular patent exists. Now, finally, I have one more question here. Can B manufacture this product in China and sell it in India? That means here I'm making an assumption. Assumption is that there is no corresponding patent right for the product X in China. And of course, I know that in India, there is no such corresponding patent. So therefore, I am free to make that product in China where there is no patent right exists for X. And also I can import them and sell it in India. So therefore, here we can try and understand how patent rights apply. That is, patent rights are territorial in nature. In other words, they are confined only to the country which grants the patent to a particular product or a particular process. Okay, now let's move on. We have another 15 minutes. I think we have to quickly move on. Now let's look at the types of intellectual property rights. when you talk about patents, patents are for inventions, and inventions could be new or improved products or processes. We are going to look into more detail in the next session. And when we talk about designs, see, more often we are not influenced by the way it works. That is, we are looking at a product. We may not be much particular about how the product works, but how it looks. So aesthetic appealing features of a particular product has a visual impression in me. That is, in other words, I'm influenced by the way product looks, but not the way it works. So for example, you could have something like this, and which is visually appealing, particularly for ladies. Yes, of course. It has nothing to do with how it works. It just looks nice, so I'm interested in that. Right? It's a new design, something like that. Well, I don't know who would like to sit on this, but nevertheless, it has an eye-appealing feature. So it looks nice. A chair. So it could be a design. Oh, this is also type of chair. And here, when you look at this chair, we find what is it that it is visually appealing here. What I see are contraptions or the devices, mechanical in nature, and it gives me an overall look of that. So therefore, when you want to look at the design need not necessarily be, it should be solely non-functional in nature, but it could be a combination of functional and non-functional, such as this chair. Smartphone, let us look at this. This is one of the significant design. This is intellectual property where Apple and Samsung, they fought for 11 years on a device that it looks. So Apple has a design patent, which you see on the left side, for which they claim this bezel as well as the shape of the phone, where you have rounded edges, and also the button here, central button here. So for which they obtain a design registration. In US, it is called design patent, whereas in India, we call it as industrial design. They call it as design patent, non-utility design patent. And now Samsung started producing, which you see on the right side, Galaxy phones having a very similarly looking design of the Apple's phone. And they also have a grid of icons for which also Apple has had a design patent. Now, when Apple sued Samsung, they sued for about $1 billion damages. And the fight went on for about many years. And then ultimately, court awarded, rather in US, it is jury awarded them about $540 million of damages against Samsung. Then ultimately, in the year 2012 or 13, Apple and Samsung, they entered into an agreement and they entered into a settlement. Nobody knows what was the amount settled between Apple and Samsung. So that is just to highlight the importance of this intellectual property. See, it may look so simple, but look at the enormity of the impact that it can cause. It is like, make or break it. Other type of IPR is copyright. This is for protecting expression of an idea. That is, if you have an original expression of an idea may be a known one could get protection in the form of a copyright, that is right to copy. The author or the owner alone will have a right to reproduce that particular expression of an idea. See, here, the interesting thing here is ideas are protected as patents. mostly the functional ideas, whereas non-functional ideas, that is expression of ideas, you can protect as a copyright. Let me give an example. Say, if you take a Ramayana, we have various expressions of Ramayana, starting from Valmiki's to Ramanand Sagar. But the characters are same, storyline is same, but nevertheless, there are various versions of same idea, and each versions could qualify for a copyright because they are the original expressions of a known idea, right? Then trademarks, which we have seen, it gives you an idea about source or quality of the product. So for example, I go to a showroom where you have many brands. Say you have Maruti, you have Toyota, so on and so forth. So when I enter into a multi-brand showroom, the salesman will come say, why don't you look at the Maruti? Why don't you buy a Suzuki vehicle? But I say, no, I want to buy a Toyota one because by looking at the mark, I have in my mind certain attributes attached to that particular brand. Say, okay, if Toyota means there is a reliability, the quality is good. So that's a conception that I have in my mind, which I relate to that particular product. So trademarks serve that particular connection between a consumer and the product. That's the value of trademark. Then, of course, trade secrets. You must have heard about Coca-Cola's formula. Some years ago, there was a big news saying that the formula for Coca-Cola was out. And after that, nothing happened. So it is said that formula for Coke is only known to two people. That is in Atlanta. One person stays and the other person travels. So they don't travel together. And nobody else knows how the formula, how this Coke is made. See, imagine a situation where Coke, now it is said that they own most of the properties in Atlanta. Let us say that they sell off all their properties, tangible assets, but they retain only the formula for the Coke, so they can survive. But if the formula of Coke is leaked out, Coca-Cola may not exist. So that's the value of trade secrets. And in India, unfortunately, we don't have law yet to protect the trade secrets in India. Now, so these are the laws we have in India: Patents Act, designs, trademarks, copyrights, and geographical indications. Now, what is a patent? Patent is nothing but a deed or a document given by a state to the inventors. So it gives an exclusive right, that is, right to exclude others from practicing the invention, which we have seen. So what is this exclusive right? This right prevents others from making, using, and selling the patented invention. Now, when you go back to trademarks we see they're encountered by everyone in our daily life because it creates a brand identity for the business. Consumers, as I mentioned, I have given an example. This consistent use of trademarks helps consumer to recognize a brand like Toyota. And trademarks identify ownership and quality. If you look at the characteristics of trademarks, there are some characteristics that are appropriate for trademark. That is, inventive trademark or coined trademark, we say, for example, Pepsi. That means this expression is a coined expression, nothing to do with the product in relation to which the mark is applied. It could be an arbitrary mark like Apple trademark, nothing to do with computers. Or a suggestive mark like Jaguar. That is to say that this particular vehicle is as fast as Jaguar. So you're suggesting that, like, say, for example, Hercules for cycle, to say that the cycle is strong as Hercules. Descriptive marks are considered to be weak marks. Say, for example, if you have a laser gauge, you can call it as a laser gauge. So they are very weak marks. And one can also protect names as trademarks. If you look at the value of trademarks, you can see the Google 164 billion and Microsoft 204 billion. Apple's mark is worth 307 billion, and we have our own Tata mark and Mahindra, which is about 13,000 million, so on and so forth. So this is the value that companies derive from intellectual property. You have to bear in mind that the value indicated is not for the physical assets that they may have, but only for the intellectual property that is derived. So whether the trademarks can be only names and logos, yes, you can have names, you can have coined expressions, you can have logos, combination of names and devices, so on and so forth. You can also have trademarks for shapes. Here you can see Coca-Cola bottle shape as a trademark, and the shape of a chocolate here that can also be protected as a trademark shape. Slogans, signature, and sound. This is an interesting thing. Sound is something which we call it as a non-conventional trademark. Just have a look at that. Just hear this sound. Probably you would recognize this sound of a lion's roar, right? And in addition to that, you can also have registration of smell. However, it is not allowed in India. So for example, American telecom company, Verizon, once you enter the outlet, say in US, you get a nice, unique, flowery scent, which is unique whenever you enter into this particular outlet of Verizon. So that smell was registered by Verizon company in US. So we have a law in India, that is Trademarks Act 1999. It provides for registration of goods and services. And there are certain things which are prohibited, like if you are trying to register a well-known mark, say for example, if you want to register Tata mark for some other thing, or if you want to just go and register marks just for the sake of defensive registration, not to use them. And also there is also prohibition that you cannot register a company name of someone as your trademark. So if you look at the definition of the mark, it says a mark should be represented graphically, and it should distinguish the goods. Shape and packaging and combination colors are also allowed to be registered here. The point I want to emphasize here is that Indian law requires something called capable of being represented graphically. That means if you are, say for example, you want to register this slogan, just do it. You have to file an application by representing this particular representation, and then you say that this representation distinguishes from others. So that is what we call it as capable of being represented graphically. Right. Now, whether this particular capable of being represented graphically can be applied to non-traditional marks such as color, shape, sound, and smell. So for instance, smell, how are you going to represent graphically? Say for example, you want to protect a benzene, that is you want to say that C6H6 or a benzene ring. Or if you want to protect as a sound, do you have to provide a musical notations? So here something which we are going to see is evolution of laws. So trademark laws, when they were formed, these are the marks which were not prevalent in those times. So now as the technology changes, so things are changing. So we have new and new products are coming up, and new attributes are coming up. As a result of which, law fails to catch up with this new attributes. Let us see how law handles this. When you look at the shape of a trademark, what you see is a very famous lighter, a Zippo lighter, where in India, for the first time, the shape of the trademark as a shape was protected, and it was enforced. Now, let's move on to other non-conventional trademarks, the sound marks. Here, as I was trying to say, whether these marks are distinctive and how graphical representation can be provided in order to achieve this registration. This is a classic example to show you about the Lions Roar for which MGM sought protection in Europe in the year 1996. So when they filed this application, they filed this along with the sonogram that you see here. So when they filed this application for Lions Roar in the 1996, in the form of a sonogram, which is a graphical representation, the appellate board refused to consider, saying that it is not clear and distinctive because Lions Roar is not uniform. Lions Roar can be of different pitches. So, and they also said that time and frequency could not be made from the sonogram, so there is no precision. And they rejected the application, trademark application for the registration of sound by MGM. However, after maybe about, say, 12 years in the year 2008, they again filed the application. And when they filed this application, this is the representation where they have shown the pitch and frequency here. And this is for the Lion Roar graphical representation showing the musical notations. And they succeeded in securing the registration in the year 2008. And whereas in case of a smell, in US, smell registration, smell as a trademark registration is allowed, which is the Verizon, as I was mentioning. They registered for the smell, and it is no longer valid because trademark registration initially is valid for 10 years. And if you want to continue, you should keep on renewing it till the time you require. Otherwise, it will be abandoned. Now, back to India. One of the earlier sound marks that are registered is Britannia Industries, where you all know this corporate jingle of Britannia Industries. This is registered. ICICI Bank also have a similar jingle registered. And one of the first marks, that is immediately after MGM's mark was registered in Europe, Yahoo filed an application in the 2008 by providing a graphical representation for Yahoo that you can see here. And it is something like Yahoo Hotel. So when you want to register a sound marks, you can provide this graphical representation along with an MP3 file, so that if it is distinctive, you can get the marks registered. Right. So far, we have seen intellectual property rights. What are the characteristics of intellectual property rights? Types of intellectual property rights, and little more about trademarks. And now we are going to see the importance of intellectual property rights. So, what are the risks then? If you don't have, if a company doesn't have intellectual property rights, there is a possibility of getting involved in expensive infringement lawsuits. They are very risky in the sense that the company makes a product and starts selling it. Maybe after 5 years, it is like some other company comes out and says, hey, you are infringing my patent right, so therefore you pay me damages. So it's going to be a make or break situation for the company who has been making and selling this product for several years. And if you don't have intellectual property rights, it is difficult to counterattack if somebody alleges infringement. And the worst scenario is that if you have a new technology, a new product, and if you don't have intellectual property, it could be easily copied by your competitors. And you can use your markets. And it is very difficult to expand business internationally because unless you have a protection in the form of an intellectual property right. And finally, when your organization having employees, how to motivate the employee. That is, one of the ways of motivating employees is by providing rewarding inventors for their contribution to the inventions that they make for the company. Okay. Now, key takeaways from this is that intellectual properties or knowledge goods, there are various species. Species are protected under relevant laws. IPR laws are territorial. And in technologically driven economy, IPRs have significant contribution. And as I said, non-conventional trademarks can be registered. And there is no law yet in India for protection of trade secrets. So with this, I try and wind up this session so I can take questions from your side.
Um, that was such a fruitful session, sir. Thank you, sir, for giving your valuable insights on IPR. Now, participants can raise your queries in the chat box, if any. So let's wait for a few seconds.
Sure.
So far, no queries have been raised in the chat box, sir. It looks like they understood the IPR concepts well. That's great. Okay, now I invite Mr. Jarinjio Jacob, Assistant Professor from Department of AI, to propose a word of thanks. Over to you, Jarin, sir.
Good evening, everyone, and thank you so much, Syllabus. Uh, so, for the past 1 hour, it has been so useful to every one of us, on hearing about the intellectual property rights. Mostly, there are some students also in this session, so they would have got it. What is the trademark? What is it? Say the marks. What is the copyright? They would have been seeing this or hearing this about these these terminologies. But now I believe after this session, they would have got what is actually it is, why we are using it, and what was the characteristics of the IPR, types of IPR, trademarks, how it is so important, why, what is the need for protecting our, like say our like say ideas, creativities, and all. So it was so useful, and I believe it was uh, 1 hour full of knowledge to everyone who listened to this wonderful session. So we are thankful to Advocate Sir J. Suresh sir for taking up the session, such a wonderful session for us for the last 1 hour. Thank you so much, sir, for giving us sharing your knowledge. Thank you so much for sharing us your thoughts. And it has been great support from our college administration, especially Suja madam. She's here with us. So thank you so much for the management for the support, and our principal, vice principal, and all the head of the departments, especially to the coordinator of this program, Dr. Smita Miss. So she have been working on this for the last few weeks. So a special thanks to Smita Miss and all the participants who have joined here, especially to the students and all the teachers, all the industrials who have joined here as part of this to get the knowledge on the intellectual property rights. Thank you so much for sharing your time with us. We can continue the series on the coming weeks as well on the Saturday, same time, 4 to 5. So we hope your participation on the coming week too. Thank you so much, everyone. Have a great evening. See you on all on the next week sessions as well. Thank you so much.
Thank you for your time. Thank you so much.